Let's take a look at sources of review authority. Most judicial authority to review agency actions comes from statutes. Constitutional and common law also provide for review. In the federal system, most review authority is derived from statute. The common law system of review has largely been replaced by legislative declarations concerning the availability of review. Congress enjoys great discretion when legislating in this area. It may establish when the review must be sought, where it must be sought, and it may set limits on the judiciary's authority in reviewing agency action. Generally, when a statute provides for review, no other method may be used to establish a court's authority to hear the case, with the possible exception of cases in which the constitutional issue has been raised. If a statute does not provide for review, non-statutory review may be available. There's a strong preference for the courts to review. Similarly, there's a strong presumption that Congress does not intend to preclude review when a statute is silent on the subject. At common law, courts could issue various writs to agencies and agency officials that were not specifically provided for by statute, such as certiorari, remedies, habeas corpus, and prohibition. The authority of federal courts to issue writs continues today because Congress has provided for certain of them by statute. However, in the federal system, certiorari is no longer available. It's been replaced by the injunction and declaratory judgment. Similarly, the writ of prohibition is a dead letter in federal administrative law. Review is different in every state, although many, if not all states, have some statutory form of review. Some continue to recognize all common law writs. Other states do not recognize the writs as an alternative to statutory review. Many agency decisions involve findings of fact. Many others require policy and political decisions. Agencies are better equipped to find the facts, in most instances, than the courts. An agency will also be more familiar with the history of a particular case as well as the facts of the industry. Decisions that are inherently political or that involve policy concerns are better left to the agencies because they're better equipped than the courts to deal with such issues. For this reason, decisions have been committed to agency discretion are not subject to judicial review. If a lawsuit is filed stemming from an action committed to an agency's discretion, it must be dismissed because the reviewing court lacks the authority to hear the case. This prevents review of procedural as well as substantive issues. The decision or action is common in the daily management or operations of an agency. It's likely unreviewable. The Constitution also plays a part in determining if review is available. The legal system of the United States is adversarial. Article 3, Section 2 of the Constitution limits the jurisdiction of federal courts to cases or controversies. This means that an actual dispute must exist before the federal court can exercise jurisdiction. Theoretical and hypothetical disputes may not be decided by a federal court. The purpose of the case or controversy limitation is to prevent the courts from becoming lawmakers, a responsibility reserved to Congress. By requiring a genuine conflict between real people, courts react and apply the law, as opposed to reflecting abstractly to make new law. What is the relationship between standing and statutory rights for review? First, if statutory law is silent on the question of who has a right to petition for review, standing principles apply. Second, if statutory law narrows or limits the group that can seek review, the statute applies. Third, if a statute makes review available to those not qualified under standing principles, the statute is likely constitutional. The standing doctrine stems from case or controversy limitation of the Constitution. Standing concerns the issue of who may sue. The standing doctrine requires that the person bringing a lawsuit has a personal interest in that case. Early standing law required that to have standing, a person had to prove that a legally protected interest or right had been violated. Under this test, financial or personal injury alone was not sufficient to establish standing in many instances. This requirement proved unworkable. In many cases, courts had to address the merits of a case simply to decide whether standing existed. It was therefore time inefficient. A new test was developed which is the subject of the data processing case. A new test of standing has 3 prongs. First, the plaintiff must suffer an injury in fact. Second, the interests asserted by the plaintiff must be arguably within the zone of interest to be protected or regulated by the statute or constitutional guarantee in question. Third, it must be shown that it's likely that the injury will be redressed by a favorable decision. Under this new test, economic and non-economic injuries are sufficient to establish an injury in fact. Even somewhat abstract injuries, such as aesthetic, recreational, or environmental injuries, may establish standing under the new test. A person's status as a citizen does not confer a right to challenge a law or agency action. That is, disagreement with a law or government behavior without an accompanying harm is not sufficient to counter standing. Like citizenship, voter status does not automatically confer standing to challenge government action. In some cases, the Constitution may create a right that will confer standing. This is common in criminal cases. Various rules govern review that may be sought. Primary jurisdiction applies in cases in which a private party sues another private party about some matter that's under the control of an agency. Related to the doctrine of primary jurisdiction, the doctrine of exhaustion of administrative remedies is concerned with the timing of a review petition. The exhaustion doctrine provides that all administrative remedies must be pursued and exhausted, completed, before judicial review is available. The administrative process will be given a full and complete opportunity to correct its own errors before judicial intervention occurs. Ripeness is concerned with maturity, that is, whether a case is sufficiently mature to be heard by a court. The APA provides for review of final agency action, with the exception when provided for specifically by statute or when an agency is clearly violating the law, only final actions may be reviewed by courts. Agency investigations, hearings, and rules that are under consideration but not finalized may not be appealed. Once it's determined that review is proper, the next question must be asked: what is the scope of review? In other words, how far will the court delve into the agency's fact findings, conclusions of law, and analysis? There are 2 sides to the scope of review coin. On one side, review of agency actions is necessary to prevent abuses. Without judicial review, individuals would be at the mercy of administrative agencies. On the other side is the need to defer an agency's expertise and experience. Judges are not engineers, doctors, or electricians. The degree to which the court defers to an agency's decision is known as a standard of review. Some standards offer significant deference, others don't. There are many standards of review, but the 3 most commonly applied are de novo, substantive evidence, and arbitrary and capricious. De novo is Latin for anew. Under the de novo standard, courts review agency decisions anew. That is, no deference is given to the agency's factual finding. Under the substantial evidence standard, reviewing courts may examine the facts found and conclusions reached by an agency. For discretionary actions not committed to agency discretion, judicial review is available under the arbitrary, capricious, abuse of discretion standard. Factual findings are treated differently than legal conclusions. 3 standards of review are applied to factual issues: de novo, substantial evidence, and arbitrary, capricious, abuse of discretion. As a general rule, review is limited to those issues raised at the administrative level. Failure to raise an issue or assert a position at an administrative level bars the party from raising an issue on appeal. An agency must issue findings and conclusions following formal adjudication. Formal rules are reviewed under the substantial evidence test. Informal rules are tested under the less stringent arbitrary and capricious test. Interpretive rules may be tested under the de novo test because they're not actually rulemaking but are an agency statement of what the agency believes a statute to mean, and determining the meaning of law is a responsibility of the judiciary. Federal courts give deference to agency interpretations of laws that fall within the agency's jurisdiction. 4 common law doctrines may be applied by reviewing courts or administrative agencies. The foundation of the 4 doctrines is the same: fairness and economy. The four doctrines were developed by the courts in the context of judicial cases. The doctrines, however, are important to administrative law as well. Res judicata and collateral estoppel are applicable in administrative proceedings. The status of applicability of equitable estoppel is not clear. In the administrative context, the doctrines may play a dual role, one on the administrative level and another at the judicial level. Res judicata is defined as a matter adjudged, a thing judicially acted upon or decided, a thing or matter settled by judgment. Collateral estoppel is similar to res judicata. Whereas res judicata prevents the relitigation of claims, collateral estoppel prevents the relitigation of issues. As with res judicata, a person asserting that an issue is estopped bears the burden of proving that collateral estoppel is applicable. The elements of collateral estoppel are significantly different from the elements of res judicata, though. Be aware that the Supreme Court has recognized two significant exceptions to the standard res judicata and collateral estoppel rules. First, in some instances, identity of parties is not required. This is referred to as non-mutual collateral estoppel. Second, the court has eased the common law restriction on who may assert collateral estoppel. At common law, only defendants could assert the doctrine. Equitable estoppel prevents parties from raising issues or asserting certain arguments. Generally, if one person makes a representation to another, that representation is relied upon. The party who made the representation is stopped from arguing the contrary. The last common law doctrine to be discussed is laches. If a party fails to raise an issue or right until at such a time that an adverse party has been prejudicated, then laches may be used to stop the first party from asserting the right or claim. Laches may be applied even if statutory deadlines are not violated.